Thanks. Is everybody ready at the main jail?
Yes, ma'am. Yes, Judge.
Okay, I'm sorry, Mr. Reedy?
There are two that the main jail would like called out of order.
Oh, okay.
One, I think, is basically the last case on the docket, Mr. Pierce. And the other is a few pages before him, Mr. Turner. Turner. Page 7. Terrence Turner.
Okay, folks, you're here for your first appearance hearing. I'm here to determine if there's probable cause for your arrest, to determine whether you should have a lawyer appointed to represent you from the Public Defender's Office. You do have the right to counsel. If you want to have the public defender appointed, you need to fill out the application for indigency, and you're going to have to pay a fee of $50, which will be due in 7 days. The public defender is not free. If you get the public defender and you're ultimately found guilty or plead guilty to the charges, there will probably be a lien filed against you for the reasonable value of their services. The third purpose is to determine what type of pretrial release should be set in your case, whether you should be released on your own recognizance, on a monetary bond, or on a pretrial release program with certain conditions. You certainly have the right to remain silent, and you're not required to say anything. Anything you do say can be used against you. And of course, you have the right to communicate with counsel or family or friends, and if necessary, we'll provide you with reasonable means to do so. Okay, I understand the jail wants Etheridge Curse first.
Mr. Curtis, come on up, please. Mr. Curtis is approaching, Judge.
Okay, this is a capias for felony battery with a prior conviction. It looks like it's an upgrade. I do find probable cause. Did the state want to be heard as to bond?
Yes, Your Honor. The state would ask that the original bond amount be put on, which was $1,000, Your Honor.
We couldn't hear the state judge.
The state asked for a bond of $1,000.
Judge, right now, Mr. Curtis is currently, my understanding is he's on a no bond, VOP hold, Judge, so he's not gonna go anywhere until that violation probation matter gets resolved. He advised me basically that he's looking for work. He thought he obtained employment, he has a job waiting on him, but he hasn't received a paycheck, so he really has no sort of funds. Judge, we'd be asking you to consider a $500 bond.
Okay, I'm going to set bond in the amount of $750. You're to have no contact with the alleged victim. And as I say, I do find probable cause. Good luck to you, sir. Okay, and Terrence Turner.
Mr. Turner, come on up, please.
Okay, Mr. Turner, you're here. You're here on an added charge. It's a capias for attaching a tag not assigned to your vehicle. The bond is set at $50. I see that there's a capias. Do you want to resolve this with a plea of no contest?
I don't believe that would be in his best interest, Your Honor. Mr. Turner is being held on a violation of probation. If he entered a plea to this, it could have an adverse effect on the resolution of those matters.
Okay. Okay. Well, the bond is set in the amount of $50. Good luck to you, sir.
Good luck, sir.
Okay. Sean Sterling.
Mr. Sterling is approaching, Judge.
Okay. Mr. Sterling, you're here on an out-of-state hold for felony possession of marijuana. It says that no bond is available. Confinement, I'm looking at the last page of the paperwork that I got, and it says, be advised, we will not extradite the above-named defendant. Please release the hold.
Is this on Sean Sterling?
Yeah, Sean Sterling.
That sounds like Good advice,
Sounds like
Judge.
an R1.
Sounds like it to me. You see?
Yeah, but they, hold on. Can we put them on recall, because I believe they sent another.
Okay, okay, I'll recall it. Confinement seems to think they got another communication from New York, so just have a seat and we'll be back with you in a few minutes. Danya Faravari,
She's here present, Judge Amin. Come on up, ma'am.
all right, ma'am, you're here this afternoon charged with possession of cannabis, 20 grams or less. Bond is set in the amount of $100. I do find probable cause.
Judge, in speaking with Ms. Exactly.
Right.
Judge, this is her first exposure to the criminal justice system. She's a registered voter.
Yeah.
Been here basically her whole life. Graduate from Western High School. Considering this is a cannabis nonviolent offense, she's going to Broward College. Judge, I'd ask you to go ahead and ROR Miss Miza Yanpour on her own recognizance.
Are there any drug priors?
Your Honor, there are no priors, Your
There's
Honor.
no priors?
Correct. However, state's position is that $100 bond is reasonable, Your Honor.
Okay. She doesn't want to resolve it today with a withhold? Okay.
No, it wouldn't be in her best interest. She wants to be a registered nurse. That might
Okay,
influence-
that's fine.
And she might be eligible for a diversion program as well and get the
I'm
case
sure she
dismissed.
would be, yeah. Okay, yeah, I'm gonna go ahead and release her on her own recognizance. That means,
I
ma'am, you
appreciate that.
understand you've got to come back to court when you're noticed to do so. Do you understand that? Okay, good luck to you. Shane Thomas,
Hi.
where are you?
She's in
Paul Ryan.
Paul Ryan, Judge.
Okay. All right, Ms. Thomas, okay. This was a change of charge to burglary of an unoccupied dwelling. Okay, and I do find probable cause. Did the state or the public defender wish to be heard as to bond?
Your Honor, Ms. Thomas is represented by private counsel Barry Whitland.
Oh.
I made contact with Mr. Whitland's office. I tried to reach him, but he did not pick up his cell. My understanding is that Ms. Thomas has a court date next week, and she's currently being held without bond on her unrelated matters. So I would ask for a nominal bond on this, and she can go in front of her division attorney and resolve these matters, or
Original bond was $3,500, Your Honor.
That's what she's being held on originally?
Yeah.
Okay.
is that okay?
In the other case?
The other cases are no bond, 2 and 3 anyways.
Oh, okay.
Right, so she's
All
not,
right.
she's not going anyplace.
She's not going anyplace. The bond will be $1,500. Okay, good luck to you, ma'am.
Good luck.
Thank you.
Say hi to Mr. Whitland for me.
I sure will. Thanks.
Allison Williams. Used to be my next door neighbor. Okay, Miss Williams, you're here on burglary of an occupied structure and violation of an injunction, but apparently not domestic violence. Okay, and I do find probable cause for those charges. Did the state or public defender wish to be heard as to bond?
Yes, Your Honor. I've been trying to reach her brother. She indicated to me that she would be able to stay with her brother if I can find him. She's been through a pretty rough time lately. I don't know if the court has a copy of her booking photo in front of you, but she suffered some pretty glaring injuries in this confrontation with the alleged victim in the case. I'd ask the court to consider pretrial release pending verification of her brother's address. I can give a phone number of the brother to pretrial release so they can hopefully do that.
Okay, has pretrial interviewed her?
No, Your Honor. Yes, Your Honor, she has been interviewed, but she has not yet been verified.
Okay, all right.
And Your Honor, state's position would be as to bond amount, $3,500 each count, Your Honor.
Okay.
Judge, I don't think she's going to be able to post any kind of monetary bond whatsoever.
Okay, what I'm gonna do is, I'll admit her to pretrial release if the addresses are verified. If the addresses are not verified, there'll be $1,500 on count 1 and an additional $750 on count 2. And if you are admitted to pretrial, then of course you'll have to report to pretrial immediately upon your release from jail and abide by any conditions that they impose upon you. And in addition, you are to have no contact with the alleged victims Eunice Holston or Leotis Breedlove, and Leotis Breedlove.
Your Honor, is this a standard pretrial supervision?
Who's Leo?
Standard pretrial supervision, yes. Okay, good luck to you, ma'am.
Your Honor, I'm also gonna ask the court to sign a photograph order.
Yeah, that's fine.
Yeah, please do.
Okay, Stephanie
I will.
Michalik. All right, ma'am, you're here this afternoon charged with robbery. It's a capias. I do find probable cause. Did the state or public defender wish to be heard as to bond?
She's being held, no bond on a number of other charges, Your Honor. I'd ask for a nominal bond on this case. She's gonna have to go in front of her division judge anyway. Additionally, we had been having a conversation of something she was mentioning to me about wanting to be able to contact her children, and she wanted to address the court in that regard.
Okay, ma'am, what is it that you want me to know?
My mom has my twins. They'll be 3 next month. And my public defender, Tammy from my other case, told me to ask about if they could put a stipulation where I can send them letters or pictures and on the phone with them.
Yeah,
I still
okay,
have rights or custody to them.
sure, there's no problem with communication with them. Okay, and state you wanted to be heard as to bond?
Yes, Your Honor, thank you. State's position is asked that Your Honor put this bond amount that was originally put, which is 50,000, Your Honor, as well as no victim contact.
I think 50,000 is kinda high, Judge. She's gonna be going in front of her division judge who can make a determination as to what an appropriate bond, if any, would be. She has no bond holds on other charges, as I mentioned.
Yeah, she's got no bond, she's not going anywhere. In the event that those change, I'll set a bond in the amount of $10,000, and should you post bond, ma'am, you're to have no contact with the alleged victim. Good luck to you, ma'am, and we'll
Thank you.
get that order for contact with your children. Calvin Cross? That might be the main jail. Thank you.
He's here, President Main Judge?
Yes. Okay, Mr. Cross, you're here this afternoon charged with trespass. Bond is set in the amount of $25. I do find probable cause for the charges. Did you want to resolve this today with a plea of no contest? Has he got other trespass? He only has one name.
Seems like, Your Honor, that is right now what's only pending. There are priors, but no trespass priors, Your
Okay,
Honor.
okay. So do you want to resolve the case with a plea of no contest?
Judge, I believe he advised me someone's gonna be posting his bond.
Oh, okay, fine. That's good. Good luck. Don't forget to come back to court.
No return, Your Honor?
Oh, no return to the premises, yeah. Tim Pappas?
Mr. Pappas is here present, Judge. He declined the service as public defender.
Okay.
Sir, I may need that if I have to stay here, because I'm gonna lose my job.
Okay, Mr. Pappas, you're here? Okay, you're here on a misdemeanor capias from 1990 that
Yes.
charges the violation of probation in that you failed to submit a report for December 1990 and you failed to complete your community service. Okay, and on that capias from 1990, there's no bond. State, before I take any action, is there anything you want me to know, State?
Your Honor, I would just ask that it is I understand it's been quite a few years, but it is still a KPS, so I would ask for no bond and that it go in front of the division judge, Your Honor.
Okay, on, looking at the nature of the violations and the age of this, I am going to terminate the probation and dismiss the warrant. Good luck to you, sir.
Thank you.
Raekwon Washington?
Judge, I'm sorry.
Mr. Washington's here present, Judge at Maine. He thinks
I
someone's
terminated the
posted his bond. Is there any way,
probation
that can
and
be
dismissed the
confirmed?
warrant. I'm sorry,
In speaking to Mr. Washington, he thinks his bond has already been posted. Is there any way
Oh,
to
okay, let's
confirm
find
that or not?
out. Has
Thank you.
Mr. Washington's bond been posted? Raekwon, 500 and 250.
Yes, it's being posted.
Okay, yeah, his bond's been posted.
Probable cause found?
Yes, I do find probable cause. Good luck to you, sir.
Just be on the lookout. A notice is gonna come in the mail. Make sure you go to court, okay? Or else it'll be right back.
Shane Roberts?
Mr. Roberts is here present, Judge Amain?
Yeah, Mr. Roberts, you're here charged with petty theft. Bond is set in the amount of $100 and possession of cannabis, under 20 grams, no additional bond being necessary. I do find probable cause. State, are there prior drug charges? Do you want to make them an offer for a plea of no contest?
There are prior charges, Your Honor, from 2012, possession of alprazolam, possession of cannabis. Those are the drug priors, Your Honor. There is additionally a leaving the scene of an accident from 2012 and a DUI from 2000.
Okay, so do you want to make him an offer for a plea of no contest? Mr. Roberts, do you want to hear an offer for a plea of no contest? Okay.
Yeah, please.
I would just do, Your Honor, to count one, a withhold court cost and no return, and that's to count two, a withhold court cost.
Okay. All right. If you want to resolve the case with a plea of no contest, on count one, I'll accept that plea. It's a withhold. The court costs, which I think are going to come out to $293, and no return to Target, 4400 North State Road 7. On the possession of cannabis, it'll be a withhold and count two costs of $28. And you're going to have 180 days from your release from jail to get those court costs paid. Good luck to you, sir.
5,400.
Yeah, you'll have 6 months.
Deontay Collins.
Did you need me to come over there? Judge, I've been invited, Mr. Collins bonded.
Okay. Patrick Bellham.
I've been advised he bonded as well, Judge.
Hezekiah Jones.
Mr. Jones is here present, Judge Amain?
Okay. Mr. Jones, you're here this afternoon charged with grand theft of a firearm and 3 counts of possession of a weapon or ammunition by a felon. Bond is set in the amount of $1,000 on count 1 and $25,000 as to each of counts 2, 3, and 4. And that is on an arrest warrant. I can't hear you. Yes, I have it. Yeah, I got it.
Judge, I don't think there's probable cause for any of these charges.
Did you get this? Did you get the addition to what I got?
I did.
Okay. And
That's my partner. He's arguing that there's no probable cause.
In the light most favorable to the state, Mr. Jones has posted photographs on the social media network of him holding an object. Whether that object is a gun or not, or a firearm or not, has not been established beyond probable cause. Even if they do claim to have an expert, without actually having that object in their possession to determine whether it is capable of expelling a projectile by means of an explosion, which is the definition of a firearm, there is no probable cause. There is no firearm. And there is no theft of a firearm, as it does not appear from my reading of the documents that Mr. Jones ever is accused of having stolen a gun.
I didn't see that. I didn't see an accusation for the theft. Does the state want to point me to something that I may have overlooked?
Now, the judge can give the state 24 hours.
We
to
can
perfect
hear
that
you.
petition. Oh, sorry. Sorry.
In the first part of the probable cause affidavit, it's just a conclusion that it was a stolen Ruger P-Series handgun. He said he bought it for $100 from somebody who stole it, which isn't the same as stealing it. State?
I'm sorry, Your Honor.
Okay. I'm finding no probable cause as to counts 1 to 4, and does the state want it continued for time to get additional information?
Yes, Your Honor.
Judge, I don't know how, I'm sorry, I didn't mean to interrupt you, go ahead. Judge, I don't know how they can possibly perfect this.
Well, we don't know.
But if it's just Mr. Jones posting videos and photographs of an object that can't be established as it's actually a firearm, what are they going to do? How do they perfect that?
Well, but there is an allegation of an actual firearm that was found, the firearm in the picture that was identified. So I'm going to go ahead and give them the 48 hours.
Very well.
Actually, Judge, are you giving them 48 hours or 24 hours? We'd be asking you to just give them 24 hours.
Either they have a gun or they don't.
24 hours,
Okay,
yeah.
thank you, Judge.
Okay. All right. Mitchell Harrington. Mitchell Harrington. Somebody
Mr.
have
Harrington,
him?
come on up, please. Thank you, Judge.
Okay. Mr. Harrington, you're here charged with 4 counts of dealing in stolen property, 4 counts of providing false ownership information for pawning, and 1 count of petty theft. Bond is set in the amount of $3,500 as to each of counts 1 through 4, $1,000 for each of 5, 6, 7, and 8, and $100 for 9. And I do find probable cause for the charges. Good luck to you, sir.
Judge, respectfully, Mr. Harrington at the state can verify, his last serious prior, I believe, was back in 1999. This is a total of $18,100 bond. He's 36 years old. He's self-employed. He's a boat mechanic. He averages about $475 a week. He lives in Wilton Manors with his parents. Been there for 8 years. He's going to call his dad to help post his bond, but his dad is retired, so unfortunately, financially, is very slim. He has 2 kids that he pays child support. One he pays $400 a month. The other child $200 a month.
Okay, that's fine. That's fine. On count 1, dealing in stolen property, I'm going to leave it at $3,500. Counts 2 to 4, I will reduce to $500. The first count of false ownership, I'll leave at $1,000, and the remaining 3, I'll ROR 'em. And the 100 on petty theft. Okay, good luck to you, sir.
Thank you.
Chad Boma. Anybody got Chad Boma?
Mr. Boma. Chad. Mr. Boma.
Mr. Potts is the other one, sir.
Sorry about that.
That's all right. Everybody's sleepy, I get that. Okay, Mr. Boma, you're here this afternoon charged with possession of heroin. Bond is set in the amount of $1,000, possession of drug paraphernalia, no bond necessary, and burglary of an unoccupied dwelling. I do find probable cause for the charges. State want to be heard as to bond on the burglary?
Yes, Your Honor, state would be requesting $3,500, Your Honor, as well as, no victim coverage.
Okay. All right, and on the burglary, I'm going to set bond at $3,500. And you are to have no contact with the alleged victim. Well, it was an unoccupied dwelling, wasn't it? Yeah, okay.
Judge,
Good luck to you, sir.
Judge, he's asking me if there's any way you could potentially lower it. He's homeless. He works off and on in landscaping, making about $200 a week. He has
Okay.
no money to make, no property, so
Yeah,
$3,500.
I'm gonna leave it as it is, and he can take that up with Judge Robinson, okay? Good luck to you,
Yes,
sir.
Judge.
Daniel Sherman.
Mr. Sherman, come on up, please.
Mr. Sherman, you're charged with battery on an officer. I do find probable cause for the charges. Did the state want to be heard as to bond, or the public defender want to be heard as to bond?
Yes, Your Honor, state would be requesting, bond to be set in the amount of $3,500, as well as no, victim contact with the law enforcement officer, Your Honor.
Judge, Mr. Sherman is requesting if you would consider a pretrial. He lives in a homeless program. It's called the Heart Program, which is in Fort Lauderdale. He says he gets his mail there. That's where he resides. He's a handyman. He makes about $100 a week. He's 34 years old, been living here his whole life. That's what the defense will be requesting, Judge.
Okay, and has pretrial interviewed him?
Yes, Your Honor, he's not a good candidate. He has a prior armed burglary dwelling adjudication, and he does not have any stable residence.
Okay, all right. Pretrial does not appear to be interested in him, and he doesn't appear to be a good risk for that. I'm going to set bond in the amount of $3,000, and good luck to you, sir.
Judge, would you sign a photo order?
Yes, sure.
Thank you, Judge.
Clayton Potts?
There's no contact as well, Your Honor.
With the officer, right, no contact with the officer. Clayton Potts?
Mr. Potts is present, Judge?
Mr. Potts, you're here charged with possession of heroin. Bond is set in the amount of $1,000. There's also a drug paraphernalia charge which requires no additional bond. I do find probable cause. Good luck to you, sir. Justin Rich?
Mr. Rich is here present, Judge. I believe he declined to service the public. No, I ain't declined. I said I didn't know what I was gonna do yet.
Okay, Mr. Rich, you're here this afternoon charged with, sir, you're charged with possession of heroin. Bond is set at $1,000, and possession of Xanax, which bond is set at $1,000, and I do find probable cause for the
If
charges.
the court is inclined, we'll ask that he be released to the supervision of pretrial services. He must submit to a drug evaluation, random urinalyses at his own expense if he is amenable to those release conditions, and if the court is inclined to do so.
Okay, so, Mr. Rich, do you want pretrial release?
Yes, he is interested in pretrial, Judge.
Okay, and you understand that you're gonna have to report one time a week, you're gonna have to have a substance abuse evaluation, submit to follow-up treatment, and random testing at your expense. You understand that those are part of the conditions of pretrial release?
Yes, ma'am.
Okay, and you're willing to undertake that?
Yes, ma'am.
Okay, and no drugs or alcohol? Understand?
problem.
All right,
Yes,
good
ma'am.
luck to you, sir. Report to the offices of pretrial release as soon as you leave jail.
I don't think he's gonna be able to report on time today. Could he report by 8:30 in the morning on Monday?
Yes, yeah, by 8:30 a.m. Monday
He's
morning.
gonna be released probably tonight at 10 midnight. I don't know what time he'll be released. Here's the map. You have to be there first thing tomorrow, on Monday morning.
Okay.
If you're not, there's gonna be a
Gibson
warrant issued.
Sylvain.
I don't need that. Go.
Your Honor, are you inclined to recall Ezekiel Jones, Your Honor? That's the one that you gave the state 24 hours to.
Wait, I'm sorry, you're gonna have to speak up because I cannot hear a
Yes,
thing.
I'm so sorry. Are you inclined to recall Ezekiel Jones, Your Honor? It's the one that you permitted the state to find 24 hours to protect. So
Yeah,
at least address 2, 3, and 4 counts. You inclined to bring it back up, Your Honor?
Mr.
You're
Johnson,
asking
I
me,
think
you have an
take it out.
argument you want to make as to counts 2, 3, and 4? Go ahead and make it.
Your Honor, on those 2, 3, and 4, Your Honor, a warrant was issued, Your Honor, previously, so a search warrant, so therefore probable cause was found, Your Honor.
I have a warrant to arrest, which is what I have here.
The one that you gave us 24 hours.
24 hours that you're talking, but it's all the Snapchat video.
But it's still just possession, Your Honor, of the weapon, so just being in possession of it is, state's argument is that it is enough, to find probable cause as well as.
Right,
the fact
except
that
what
it's
you
in-
have is a picture, right? Or else you have the one weapon that was seen, and these are 3 counts. These are 3 counts of, maybe you need to clear this up with me. There's 3 counts of possession of a weapon or a firearm, and it's 3 different days, pictures that were posted of the same firearm? And that's the weapon that was found that he said he bought from somebody else who stole it, right?
But because he was in possession of it, state's position is that there is probable cause, addition to that warrant being previously, signed.
Okay, but how is there probable cause for 3 counts of it, of the same weapon?
Because I
Because
believe,
they're
Your
on
Honor-
pictures on different days? It's still only one weapon.
But I believe if he's in possession of it on 3 different date of incidents, then I believe that's state's position, Your Honor.
Does the public defender want to make any argument?
But there's no probable cause here.
I don't see how that picture of it posted on Snapchat.
And again, Judge, it's a picture of something.
Well, wait a second, because on the other paperwork, it says that during the execution of the search warrant, a stolen handgun was recovered, and post Miranda, Jones stated that he bought it for $100 from somebody else. So there is an actual gun that he's actually in possession of, at least at the time that the warrant was served. What it was on those other days, I don't know. So I'm inclined to find probable cause for count 2, but not 3 and 4.
There's still no indication in this probable cause affidavit that this item is capable of firing a projectile by means of an explosion.
Well, I think that, the stolen Ruger handgun and the conclusion that it was operable gets it. That's okay. Okay, so I'm finding no probable cause for 1, 3, and 4, probable cause for counts 2. 2 is
Still us seeking the
$2,500
reward.
bond.
State still has 24 hours.
25,000, yes.
Okay.
Judge,
Okay.
on the
Good
count
luck.
that you, Judge,
Yeah,
hello?
Yeah,
On the
yeah.
count on the count that you did find probable cause on, I know he's gonna be brought back tomorrow. I just don't want the judge thinking that you left the bond in place, so he's not gonna be addressing the bond, on the count that you actually found probable cause. So is there any way we can write in the information, and then tomorrow, the magistrate judge can be presented with mitigating circumstances? Because I was gonna be prepared to.
oh, okay, yeah.
To decrease substantially the bond from the $75,000 to something more reasonable.
Okay, I get you, yes, okay. Reset for PC. Set bond. For count 2. Okay, I wrote that in.
So bond on count 2 then, Judge, is?
No, I'm leaving it since he didn't have an opportunity to make an argument when the defendant was here. I'm just leaving it and let the judge who's here tomorrow set a bond after listening to mitigating argument for count 2. Because he's not going anywhere for 24 hours anyway.
And you found no probable cause?
No
on
probable
1,
cause
3,
for
and
1,
4.
3, and 4. Okay. Gibson Sylvain.
Mr. Sylvain is here present, Judge O'Main.
Okay. Mr. Sylvain, you're charged with sexual battery of a victim over the age of 12.
Would waive formal reading.
Okay.
A little late, but
Okay. I do find probable cause for the charge. Did the state want to be heard as to bond?
Yes, Your Honor. The state's recommendation, Your Honor, is $75,000, Your Honor, as to bond. And then if he were to bond out of that, that he be tracked on a GPS monitor, and no victim contact.
Judge, as far as the defense, my understanding is, and the state could verify, this is his first arrest. He's 18 years old. He's been residing in South Florida his whole entire life. He's going to Monarch High School. He's in 12th. He'll be starting the 12th grade. He lives with his mother in Coconut Creek. They've been residing at the same location for the past 10 years. She's actually a caretaker, so it's not like they have, they don't have huge financial resources. Judge, $75,000 bond for Mr. Sylvain would be tantamount to no bond in his particular case. We'd have no objection as far as pretrial, so the court could have assurances as far as Mr. Sylvain being supervised. But we'd be asking you to dramatically decrease the bond amount from what the state requests from $75,000 to somewhere along the neighborhood of $10,000. That's maybe something that his mom could try and strive for, Judge.
Okay. And was there some basis that you know for asking the $75,000 other than the facts? Something is that a misrepresentation as to his prior record?
Your Honor, no, we do
There's
not
no
find
prior.
any criminal history. It is based on the facts of the case, Your Honor.
Okay, all right, thank you. All right, I'm going to go ahead and set bond in the amount of $10,000. And can we put pretrial monitor or something if
Yes,
he, okay,
A GPS monitor.
a GPS monitor, yeah.
He must stay at least 500 feet away from the alleged victim.
Yes, you have to stay at least 500 feet from the alleged victim, Sherry Rice. Okay, good luck to you, sir. Okay, let's recall Sean Sterling.
Mr. Sterling, come on up, please.
On X as far as the fine, we can find probable cause because it's sometimes trying to get in contact with New York. So we're dismissing that effect.
Okay. Yeah, all I have is the short arrest form confirmed by, and then the next page is, sorry for the inconvenience, we're not gonna extradite on this.
And that's the fact that we're gonna go off this.
Okay. Yeah, confinement doesn't seem to have anything else other than the reference from New York that they're not going to extradite, and please release the hold for this defendant per the New York County District Attorney's Office, Nitin Sever. Sorry for any inconvenience. Okay, so they're not extraditing, so it'll be an ROR. Okay, good luck to you, sir. Okay, and Jamal Gordon.
North Broward, Your Honor.
Thank you. Okay, Mr. Gordon, it's the defense motion for ROR. Has the state filed anything on Jamal Gordon?
No, Your Honor, he's entitled to 4 an ROR.
Okay, nothing's been filed, so you're entitled to the ROR. Good luck to you, sir.
Can I ask you a quick question?
I wouldn't.
The public defender says you shouldn't, but
All right.
Just go home, man.
things can only get worse, right?
No,
Right. Stephen Walters.
North Broward, Your Honor.
Okay, Mr. Walters. This is a second look, huh? Okay, Mr. Walters, you've been charged with petty theft.
Yes.
I don't know what the bond was originally. Maybe it was $25. Did you want to resolve it today?
I mean, either way, I resolve it, get a little, I need to get out of here. I got medical issues that I need to take care of.
Okay, so you want to resolve it with a plea of no contest?
That'll work, yes, ma'am.
Okay, all right, that's fine. On your plea of no contest, I'm going to adjudicate you guilty, sentence you to time served. And, no, was it a store?
To Publix, Your
A
Honor.
Publix. No
located
return to the Publix at,
at 100 West Oakland Park Boulevard,
no return to the Publix at 100 West Oakland Park Boulevard.
Wilton Manors, Florida 33311.
Okay, Wilton Manors. There are going to be court costs, and
Yes,
you're going to
sir.
have 180 days from your release to get those court costs paid or to do community service at $10 an hour.
Okay, thank you.
Thank you. That's all I have. Has anybody else got anybody or anything unexplained?
Judge, have a great weekend.
Thank you, you too.
Thank you.
Yes, ROR.
Yeah.
And then do we not have Marcus Jordan? No.
Do we know who's coming in next week?
It might be, oh yeah, they might be finished at North. I think it's Claudia Robinson from South.
Oh. She was my intern.
You know, I was your husband's intern.
I know. You are one of his favorites.
Oh, that's so sweet. That's so sweet. It's been a real pleasure, Judge.
Nice to
All right.
see you. I'll be back, I think, on a Monday in September.
We'll see you then.
Then. Okay, is there anything else that I need to sign that I haven't signed? Have a wonderful weekend, everybody.
Your Honor, you too.
There's off.